The deposition was taken on August 4th. The evidence it described wasn't found until August 9th. That's 5 days. 22 pages of sworn testimony about a blue canvas bag hidden under the floor planks of Marcus Dillard's kitchen. Testimony given 5 days before anyone pulled those planks up. Docket CR 28T-7741, Fulton County Superior Court, Atlanta, Georgia. The witness's name was Patricia Harmon. The transcript is page 17, line 8. The blue canvas bag, the one they found in the floor. She said that on August 4th, 2018. The bag was logged as evidence item EV 2008-0914 on August 9th, 2018. I have both documents on my desk right now. My name is Martin Kelleher. I spent 19 years as a criminal defense attorney in Atlanta, Georgia bar number 478813. I've handled somewhere north of 300 cases. Homicides, armed robberies, federal drug conspiracies, things I can't talk about even now. I don't shock easily. This one is different. Gary Okafor came to me in July of 2018. He was 29 years old. He worked dispatch for a logistics company out in Mableton, Georgia. He was charged with the murder of Marcus Dillard, a neighbor he'd had a documented dispute with over a shared driveway. 2 noise complaints. 1 threatening text message Gary sent in a moment of frustration. The DA built a circumstantial case on proximity, a paper motive, and a traffic camera that caught Gary's car half a mile from Dillard's address at the estimated time of death. No physical evidence tied Gary to the scene. No weapon. No DNA. No eyewitness who placed him inside the house. The lead detective was Raymond Stull, APD homicide. 22 years on the job. He filed clean reports. I'd opposed him before. He didn't cut corners, and that made him harder to beat than the sloppy ones. But a clean detective can only work with what the evidence gives him, and what the evidence gave him here was thin. I thought we had a real chance. The prosecution's witness list arrived in early August. Standard disclosure, 8 names. 7 of them were expected. The responding officers, the forensic tech, the medical examiner, the neighbor who found the body. The 8th name was Patricia Harmon. Her description on the disclosure form: fact witness, neighbor, direct observation testimony. Her listed address was Smyrna, Georgia, a suburb maybe 15 minutes from where Marcus Dillard had lived. No prior record, no professional affiliation with law enforcement, no apparent connection to Dillard or Okafor beyond physical proximity. I requested a copy of her deposition transcript as soon as it was filed with the court. It arrived by secure mail on August 14th. I read it that evening. It was a Tuesday. I remember that specifically because I had a sentencing hearing the next morning and I was reading the Harmon transcript instead of preparing for it. I do that sometimes. When something in a file feels wrong, I can't look away until I understand why it feels wrong. The first 16 pages were ordinary. Harmon described Dillard as a quiet man who kept to himself. She'd seen a gray sedan in his driveway 2 days before his body was found. She thought it might have been a rental, based on the plate configuration. She'd noticed his mail piling up. Standard observation testimony. Nothing I couldn't handle on cross-examination. Page 17 stopped me. The examining attorney was a woman from the DA's office named Casey Wren. She was young, maybe 4 years out of law school, and she tended to ask open-ended questions when she should have been asking closed ones. On page 17, she asked Harmon to describe anything unusual she'd noticed about the Dillard property in the weeks before his death. Harmon's answer began on line 4. She mentioned the overgrown hedge along the left side of the property. She mentioned a broken motion sensor light above the garage door. Then, on line 8, there was also that canvas bag, the blue one, the one they found in the floor. I read it 3 times. Then I pulled the evidence log. Detective Stull's supplemental evidence report was dated August 9th. A second sweep of the Dillard property, conducted that morning, had revealed a loose section of subflooring in the kitchen. Beneath it, sealed in a gallon Ziploc bag, a blue canvas tote. Inside the tote, personal documents belonging to Marcus Dillard, including what appeared to be private financial records. The item was logged as EV 28080914. Time of logging 10:47 a.m., August 9th, 2018. The deposition was conducted on August 4th. Patricia Harmon described a blue canvas bag hidden in the floor on August 4th. The bag was found and logged on August 9th. 5 days later, I checked the filing stamp on the deposition transcript. Court reporter Sandra Chu, filed August 6th, 2 days after the session. The clerk's office confirmed it when I called the next morning. Transcript number CR 28-7741DP02. Session date, August 4th, 2018. Filing date, August 6, 2018. Both dates verified. The transcript was real. The evidence log was real. And Patricia Harmon, under oath, described a hidden physical object 5 days before it appeared in any official record. I spent most of that night going through every document in the Dillard case file that predated August 9th. I pulled every police report Raymond Stull had filed, every preliminary evidence inventory, every communication from the property to the forensic team, 41 pages of documentation generated before the second sweep. Not a single mention of a bag. Not a single reference to loose subflooring. I checked the Atlanta Journal-Constitution's coverage of the Okafor arrest. I checked a local crime reporting blog that had run a brief item on the Dillard homicide. I searched 3 different news aggregators. Nothing about a bag beneath floorboards. Nothing about a second sweep. The first public mention of the bag's discovery appeared in the AJC on August 12th, 3 days after the log entry, 8 days after Harmon's deposition. Patricia Harmon described it on August 4th. The story didn't even exist publicly until August 12th. There was a second deposition, a shorter follow-up session, 12 pages, conducted on August 11th, the day before the AJC story ran. The same parties, the same conference room on Pryor Street. Casey Wren asked Harmon a series of clarifying questions about the gray sedan she'd described. The word bag did not appear anywhere in the August 11th session. Casey Wren did not ask Harmon to explain how she'd known about the bag 5 days before it was found. She didn't ask. I've been thinking about that ever since. Either she didn't notice the discrepancy, or she noticed and decided not to hand me the argument on a plate. I'll give her credit. Even a junior attorney should have caught it. But she didn't ask, or she already knew the answer and didn't want it on the record. I called Casey Wren the morning after I'd finished going through everything. I used the word inconsistency. I said I'd found what appeared to be a temporal inconsistency in the Harmon deposition. I wanted to see her reaction before I committed to a position. She said she'd look into it. 2 hours later, she called back. She said the description on page 17 was consistent with information Harmon had provided during earlier informal interviews with the investigative team. I asked for documentation of those informal interviews. She said she'd check. She never called back. I filed a formal discovery request the following Monday. All pre-deposition communications with Patricia Harmon. All notes from informal interviews. Any police report containing the words canvas, bag, or floor prior to August 9th. The response came back 12 days later. No responsive documents, that's the phrase. It's clean. It gives you nothing to argue with. It means either nothing exists or nothing is being produced, and you are not always told which. I kept the Harmon transcript on my desk for the rest of August. I kept returning to page 17, line 8. The way she'd said it, the one they found in the floor. past tense. Not I think there might be, or I noticed something once, found, as if speaking about a confirmed documented fact. But it wasn't a confirmed documented fact on August 4th. It wasn't a fact at all until August 9th. I requested Sandra Chu's full session log for the August 4th deposition. The certification listed start time 10:14 a.m., end time 1:38 p.m., parties present, location, conference room B, DA's offices, 136 Pryor Street, W. Parties listed Casey Wren, examining attorney, Patricia Harmon, witness, Tom Farrell, Harmon's counsel of record, Sandra Chu, court reporter, R. Moss, contracted videographer. 4 parties plus the reporter. I was not listed. I had not been there. The deposition was a prosecution witness deposition. My office had received formal notice. I had elected not to attend. Standard practice when a witness appears to be routine and low value. I had been in Savannah that weekend on a family matter. Hotel receipt from the Savannah Marriott Riverside. Check-in August 3rd, check-out August 5th, room 412. I was 4 hours away. That was the last thing I could say with certainty. Because in early September, when I requested the full case docket from the clerk's office, I found something on page 4 that I've been unable to explain. Entry 31, dated August 3rd, 2018. Letter re deposition scheduling. Re Patricia Harmon, fact witness. Filed by counsel for defendant M. Kelleher-esque GA bar number 47830. My name, my bar number. A letter I had apparently filed with the Fulton County Superior Court to schedule the deposition of a prosecution witness. A letter I have no memory of writing. A letter dated August 3rd, 2018, the same day I checked into a hotel room 170 miles from Atlanta. I spent 3 days trying to convince myself there was a reasonable explanation. Maybe my paralegal had drafted the letter. Maybe there was a scheduling call I'd delegated and then forgotten about in the chaos of a heavy August calendar. Maybe a junior attorney at a firm that shared office space had filed something under a similar name and the clerk had entered it wrong. Every explanation I came up with fell apart inside of 60 seconds. My paralegal's name is Denise Okafor. No relation to my client, just a coincidence that had amused Gary Okafor the first time he came to the office. Denise had worked with me for 11 years. She maintained a meticulous paper log of every document that left our office, letters, motions, discovery requests, everything. She had a color-coded binder for each active case. I pulled the CR 2080-07741 binder and went through every entry for July and August 2018. No outgoing letter regarding deposition scheduling for Patricia Harmon. No entry dated August 3rd of any kind. I asked Denise directly. She had no memory of drafting or sending such a letter. She went back through her own personal calendar. Nothing. I checked our case management software. Every document generated under the CR 28-7741 matter code from the day Gary first came in to the end of August. The system timestamps every file, every print job, every email draft. No deposition scheduling letter for Patricia Harmon, not in any format, not at any stage of drafting. The letter in the court docket was the only version of it that existed anywhere. I drove to the Fulton County Courthouse on a Thursday morning and requested the physical court file for CR 28-07741 from the records window. The clerk brought it out in a brown accordion folder. I sat at one of the public review tables and went through every page. The letter was on page 4 of the filing sequence, exactly as the docket summary had listed it. It was a single page. Standard business letter format. Our firm's letterhead, the correct letterhead, the version we had been using since 2016 when we updated the logo font, the correct street address, the correct office phone and fax numbers. In the body, it confirmed that defense counsel requested the deposition of Patricia Harmon, fact witness for the prosecution, to be conducted on August 4th, 2018 at 10 a.m. in Conference Room B at the Fulton County District Attorney's offices. It cited the docket number correctly. At the bottom, my signature. I have a distinctive signature. I've used it for 19 years. The way I loop the K in Kelleher, the angle of the M, the small upward tail I put on the final R. It looked like my signature. It looked exactly like my signature. I took photographs of it on my phone. I took close-up photographs. I sent them to a friend who does document authentication work. Not officially, not as a formal request, just to get his eyes on it. He called me the next morning and said, "That's your signature, Marty. What's the problem?" I told him the problem. He was quiet for a moment. Then he said, "Then you sent the letter and forgot." I said, "I was in Savannah." He said, "Savannah is 4 hours, not the moon." He was right, technically. Someone could drive from Savannah to Atlanta in time to send a letter by end of business on August 3rd. Someone could even drive back. The geography worked. But I had checked into that hotel on the evening of August 2nd. I hadn't driven to Atlanta on August 3rd. I hadn't had any reason to. The Okafor case was not in a critical phase. I had no hearings scheduled. My calendar for August 3rd showed a family dinner at 6 p.m. in Savannah. I still have the restaurant receipt. 2 entrees and a bottle of wine. Paid by my credit card at 7:58 p.m. on August 3rd, 2018. I did not drive to Atlanta and back in the middle of a family dinner. I decided to call Sandra Chu. Sandra had been a court reporter in Fulton County for over 20 years. She was professional, efficient, and completely reliable. I had been in her sessions dozens of times on both sides of the table. I told her I was reviewing the August 4th Harmon deposition for the Okafor case and had a procedural question about the session log. I asked if she recalled who had requested the session. She said, "The defense attorney on record filed the scheduling letter." I said, "Do you remember who that was?" She said, "Your name was on the letter, Mr. Kelleher." I said, "Sandra, I need to ask you something directly. Do you remember if I was physically present in that session?" She didn't hesitate. She said, "Yes, you were there." There was a long pause on my end. She waited. I said, "Can you describe where I was seated?" She said, "Across from the witness. You didn't ask any questions, but you were observing. You sat at the far end of the table." I said, "And you're certain it was me?" She said, "I've been in sessions with you for 15 years, Mr. Kelleher. I'm certain." I said, "I was in Savannah on August 4th. Another pause. She said, "I have you in my notes." I asked her to pull the physical notes from that session, the handwritten log she keeps separate from the official transcript. She put me on hold. When she came back, she read from the document. Parties present: C. Wren, prosecution; P. Harmon, witness; T. Farrell, Harmon counsel; R. Moss, videographer; M. Kelleher, defense, observing, my name in her handwriting, in a document she had written on August 4th, 2018. I drove back to the hotel in Savannah that evening and sat in the parking lot for 20 minutes before I went inside. The hotel's security cameras had footage from August 3rd through August 5th. I requested it through the manager, citing a potential civil matter. The footage showed me checking in at the front desk at 7:22 p.m. on August 2nd. It showed me using the hotel gym on the morning of August 3rd. It showed me returning to the hotel at 9:14 p.m. on August 3rd, after the family dinner. The footage for August 4th showed me having breakfast in the hotel restaurant at 8:47 a.m. The session on Pryor Street began at 10:14 a.m. The hotel is in Savannah. The DA's office is in Atlanta. That's 170 miles. I could not have been in two places at 10:14 a.m., but Sandra Chu's notes said I was there. and the deposition session lasted until 1:38 p.m. The hotel's lobby camera showed me returning to the elevator at 2:11 p.m. on August 4th. I remember that now. I had taken a long walk along the riverfront and come back to change before a late lunch. From 8:47 a.m. to 2:11 p.m. on August 4th, 2018, the Savannah Marriott's cameras had no footage of me inside the building. 5.5 hours. Atlanta to Savannah, 4 hours round trip. A 2-hour session in between would account for the full gap. I don't remember driving to Atlanta. I don't remember being in that conference room. I don't remember watching Patricia Harmon describe evidence that didn't exist yet. I checked my email records going back to August 2018, my sent folder, my drafts, my deleted items. I use Gmail through a client portal. Every email is time-stamped and backed up by a third-party archiving service we've used since 2014. On August 3rd, 2018, my email activity showed 4 messages sent. 2 related to a separate federal matter, 1 to Denise about Gary Okafor's next scheduled call, and 1 to a colleague about a sentencing in a different case. No email related to Patricia Harmon. No email related to the deposition scheduling. No email to the DA's office at all. On August 4th, 2018, my email showed 0 activity between 8:31 a.m. and 3:47 p.m. I sat with the numbers for a long time. Sandra Chu said I was there. The hotel camera didn't see me for 5.5 hours. The gap was there, the math was possible, and I had no memory of it. I went back to my Google Calendar, my account, logged into my phone, synced across devices. I opened August 4th, 2018. The day appeared blank. Then I scrolled down past noon. At the 10 a.m. slot, there was a single entry. CR 07741, Harmon Deposition, Prior St. DA Office, 10 a.m. The entry was attributed to my Google account, synced from my primary login. I had not created that entry. I know I had not created it, the same way I know my own handwriting, the same way I know my own signature. I had been in this practice for 19 years. I would not schedule a deposition and fail to remember it. I would not drive to Atlanta and back and have no recollection of it whatsoever. But someone had entered it into my calendar, and that someone had done it from my account. The Harmon transcript sat on my desk through October. I couldn't use it. A deposition that showed my name in the room was not the platform I wanted to challenge the state from. If I raised the temporal impossibility, the 5-day gap between Harmon's testimony and the evidence's discovery, I would have to explain why I had apparently been present and said nothing. I had no explanation. I still don't. The only card I could have played was a motion to suppress the Harmon deposition in its entirety, citing improper scheduling procedure. But that letter bearing my name was the scheduling document. Filing a motion based on it would have been filing a motion against myself. Gary Okafor deserved better, and I failed to give it to him. Gary Okafor took a plea deal in November 2018, 12 years, with the possibility of parole after 8. He maintained his innocence throughout the negotiations. I told him it was his choice. I told him I couldn't guarantee a better outcome at trial, not with the circumstantial evidence stacked the way it was, not with the Harmon deposition still in play. He was 29 years old. He looked at the math and he signed. I drove home and sat in my kitchen until 3 a.m. I didn't open a bottle. I just sat there. I hadn't told Gary about the deposition anomaly. I hadn't told him about the letter with my name on it. I hadn't told him that the prosecution's key witness had described a piece of physical evidence 5 days before it existed in any official record, and that for reasons I couldn't explain, I had apparently been present in the room when she described it, and I have no memory of it at all. What would that have changed for him? If I couldn't explain my own presence, I couldn't explain hers. He signed. I took 3 months off after that. Not a formal leave, just a slow withdrawal from new intake. I told Denise I needed to let the caseload thin out. She didn't ask questions. She's worked with me for 11 years. She knew when to let something sit. In January, I tried to find Patricia Harmon. Her listed address in Smyrna was vacant. The property records showed the apartment had changed tenants in September 2018, 1 month after Gary's plea deal. No forwarding address filed with the post office. No active vehicle registration in the state of Georgia under that name. I hired a private investigator named Reyes who does skip trace work. He spent 2 weeks on it. He found 2 previous addresses for a Patricia Harmon matching the approximate age and description. One in Birmingham, Alabama, and one in Columbus, Ohio, where she had resided briefly in 2015 and 2016. The DA's office had listed her status on the case as cooperative witness, no ongoing contact required, meaning once the plea came in, they stopped tracking her, meaning no one knew where she was. In February of 2019, I went to the Fulton County Recorder's Office and requested the physical court reporter certification from the August 4th session. Not the PDF scan in the docket, but the original paper document that Sandra Chu had filed. I wanted to see it with my own eyes. The recorder's office clerk was helpful. He brought the file within 20 minutes. I spread it on the review table. The certification was exactly what Sandra had described on the phone, typed on her standard form, her notary seal in the bottom right corner, her signature, dated August 4th, 2018. 5 parties listed. My name was the 5th. I photographed every page under the table lamp. Then I sat back and looked at the form for a long time. There was something else. Below the party list, in the section reserved for the court reporter's notes, there was a handwritten addition. Just 4 words written in a different pen than the rest of the form. Darker ink, slightly different angle. All parties confirmed present. It was initialed, 2 letters. SC Sandra Chu had added that note specifically. Court reporters don't usually do that. The party list is the party list. Adding a separate confirmation of presence is not standard practice, at least not in any deposition I'd attended in 19 years. It was as if she had anticipated that someone would later question whether one of the listed parties had actually been in the room. I called her that afternoon. I asked her about the note. She was quiet for a moment. Then she said, "I wrote that on August 4th, after the session." I asked her why. She said, "Because the atmosphere in that room was strange. I wanted the record to be clear." I asked her to describe what she meant by strange. She said, "Everyone was quiet. The witness answered questions and the attorneys were professional, but something felt off. I can't give you a better word than that. When I left, I went back to my car and wrote in my personal log. I've never done that before or since." I asked if she still had the personal log. She said she'd have to look. She called back 2 days later. She'd found the entry. She read it to me over the phone. Aug 4th Prior Saint, Harmon deposition. Unusual session. Witness described physical item before it appeared on the evidence list. I double-checked the list at home afterward. The item wasn't there. Will not raise it. Not my job, but I'm writing it down. Sandra Chu had noticed on August 4th, 2018. She had noticed that Patricia Harmon described something that wasn't on the evidence list, and she had written it down in her private log and said nothing. "Why didn't you tell anyone?" I asked her. She said, "Because I didn't know if it was my mistake. I thought maybe I'd missed a supplemental report. I figured the attorneys would catch it if it mattered." She paused. "Did it matter?" she asked. I retired from criminal defense practice the following spring. I told everyone it was burnout. 19 years is a long run. I had some savings. My daughter was in college. It was a natural stopping point. That's what I told everyone. The truth is that after February 2019, I stopped trusting the ground under my feet. I had spent 19 years believing in documents, in the evidentiary chain, in the idea that a paper record is a fixed thing, that a filing date means the filing date, that a signature means the person signed it, that a calendar entry means someone scheduled something. I built my entire professional life on the reliability of paper. Patricia Harmon described evidence that didn't exist yet. A letter bearing my name and bar number and signature scheduled a deposition I have no memory of attending. A court reporter I have known for 15 years placed me in a conference room on the same morning. A hotel camera in Savannah placed me in a breakfast dining room. And in my own Google Calendar, synced from my own login, there is a deposition entry I did not write. She described evidence that didn't exist yet, and I apparently helped schedule the meeting where she described it. I don't know how those two facts can both be true. I don't know how any of it can be true, but the documents say it is. 13 months after Gary Okafor signed his plea, I got a phone call from a public defender in Columbus, Ohio. Her name was Elaine Shorter. She'd been handling a homicide defense, and the prosecution had called a fact witness, a woman who'd given deposition testimony about a specific piece of physical evidence recovered from the crime scene. The problem, Elaine said, was that the witness had described the evidence 3 days before it was logged. 3 days, different docket, different city, different crime, same pattern. She said the witness's name was Patricia Harmon. She asked me if I'd ever encountered her in Atlanta. I held the phone. I looked at the court reporter's certification sitting in the manila folder on my desk. I looked at my name, M. Kelleher, ESQ, GA bar number 47883, listed as the fifth party in a room I don't remember entering. I said, no, I've never heard of her. I don't know why I said that. The case is closed. Gary Okafor is somewhere in the state prison system east of Atlanta. Patricia Harmon is wherever Patricia Harmon goes. And somewhere in the Fulton County archives, there is a deposition transcript with 22 pages, a court reporter's private log entry, a letter with my signature that I did not write, and a calendar entry in my own account that I did not create, all pointing toward a single afternoon on Pryor Street that I have no memory of living through. The bag was real. The deposition was real. The 5-day gap was real. Everything was real.